London Traffic Act 1924, 14 and 15, George V, c. 34. Section 7, subsection 1. Where, as respects any street or part of a street within the area consisting of the City of London and the Metropolitan Police District, the Minister of Transport is of opinion that by reason a. of the width of the street or part of the street or the density of traffic thereon, or b. of the existence of alternative facilities for the conveyance of passengers along the street or part of the street or in proximity thereto, or of the omnibus accommodation on the street or part of the street being excessive, it is desirable that an order under this section shall be made. He may by order declare the street or part of the street to be a street in which the plying for hire by omnibuses ought to be prohibited or restricted, either generally or during particular hours, and a street or part of a street with respect to which such an order is made is hereinafter referred to as a restricted street. Subsection 2. Where the Minister has so declared any street or part of a street to be a restricted street, the Minister may make regulations a. prohibiting or restricting the plying for hire by omnibuses in the street either generally or during particular hours, or limiting the aggregate number of journeys which may be made in either direction along the street during particular hours by omnibuses plying for hire. b. Determining the omnibus proprietors whose omnibuses alone may ply for hire on the street and apportioning amongst those proprietors such aggregate number of journeys as aforesaid, but so, nevertheless, that the right so to ply shall not be limited to the omnibuses of one proprietor in any case where it appears to the Minister to be reasonable and practicable that the right should be exercised by other omnibuses also, and c. Conferring on a licensing authority such powers as he may deem necessary to enable them to secure the observance of the regulations, and the regulations may provide for dispensing with or relaxing the restrictions imposed thereby in such circumstances and in such manner as may be provided in the regulations. Subsection 4. If any person contravenes or fails to comply with any such regulations, he shall be liable on summary conviction to a fine not exceeding £5, and on the conviction of a person for a second or subsequent offence under this subsection, the licensing authority shall notify the Minister of the conviction, and the licensing authority, if so directed by the Minister, shall thereupon revoke or suspend all or any licences to ply for hire in the area aforesaid which they may have granted to the offender in respect of omnibuses, provided that proceedings for any such offence shall not be instituted except by or on behalf of a licensing or police authority. Subsection 6. Any regulations made under this section shall be laid before both Houses of Parliament forthwith, and, if an address is presented to His Majesty by either House of Parliament within the next subsequent 28 days on which that House has sat after any such regulation is laid before it, praying that the regulation may be annulled, it shall thenceforth be void, but without prejudice to the validity of anything previously done thereunder or the making of a new regulation. Section 10, subsection 1. For the purpose of relieving congestion and facilitating traffic in and near London, the Minister may make regulations to have effect in the London traffic area, or any such part thereof, or places or street therein, as may be specified in the regulations, for any of the purposes or with reference to any of the matters set out in the third schedule to this Act, and special regulations applicable only at special times or on special occasions may be so made, provided always that no such regulations shall interfere with street markets nor, so far as respects matters which may be dealt with by regulations under Section 1 of the Metropolitan Streets Amendment Act 1867, with street traders. Subsection 2. Any regulations so made by the Minister may provide for the suspension or modification so long as the regulations remain in force of any provisions of any acts, whether public, general, or local or private, bylaws or regulations dealing with the same subject matter as the regulations made by the Minister, or of any acts conferring power of making bylaws or regulations dealing with the same subject matter, so far as such provisions apply to any place or street to which the regulations made by the Minister apply. Subsection 3. Any such regulations may provide for imposing fines recoverable summarily in respect of breaches thereof not exceeding in the case of a first offence £20, or in the case of a second or subsequent offence £50, together with, in the case of a continuing offence, a further fine not exceeding £5 for each day the offence continues after notice of the offence has been given in such manner as may be prescribed by the regulations. Subsection 6. The making of any regulations under this section shall be conclusive evidence that the requirements of this section have been complied with. Subsection 7. Any regulation under this section shall be laid before both Houses of Parliament forthwith, and, if an address is presented to His Majesty by either House of Parliament within the next subsequent 28 days on which that House has sat after any such regulation is laid before it, praying that the regulation may be annulled, it shall thenceforth be void, but without prejudice to the validity of anything previously done thereunder or the making of a new regulation. Third Schedule. Purposes or matters for or with respect to which regulations may be made by the Minister. 1. for prescribing the routes to be followed by all classes of traffic or of any particular class or classes of traffic or vehicles from one specified point to another, and either generally or between any specified times. 2. For prescribing streets which are not to be used for traffic by vehicles of any specified class or classes, either generally or at specified times. 3. For regulating the relative position in the roadway of traffic or differing speeds or types. 4. For prescribing the places where vehicles or vehicles of any particular class or description may not turn so as to face in the opposite direction to that in which they were proceeding, or where they may only so turn under conditions prescribed by the regulations. 5. For prescribing the conditions subject to which, and the times at which, articles of exceptionally heavy weight or exceptionally large dimensions may be carried by road. 6. For prescribing the number and maximum size and weight of trailers which may be drawn on streets by vehicles, or vehicles of any particular class or description, either generally or on streets of any class or description, and for prescribing that a man should be carried on the trailer or, where more than one trailer is drawn, on the rear trailer for signalling to the driver. 7. For prescribing the conditions subject to which, and the times at which, articles may be loaded onto or unloaded from vehicles, or vehicles of any particular class or description on streets. 8. For prescribing the conditions subject to which, and the times at which, vehicles or vehicles of any particular class or description, delivering or collecting goods or merchandise, or delivering goods or merchandise of any particular class or classes, may stand in streets, or in streets of any class or description, or in specified streets. 9. For prescribing the conditions subject to which, and the times at which, vehicles or vehicles of any particular class or description may be used on streets for collecting refuse. 10. For prescribing rules as to the precedence to be observed as between vehicles proceeding in the same direction or in opposite directions or when crossing. 11. For prescribing the conditions subject to which, and the times at which, horses, cattle, sheep, and other animals may be led or driven on streets within the Metropolitan Police District and the City of London. 12. For requiring the erection, exhibition, and removal of traffic notices, and as to the form, plan, and character of such notices. 13. Broken down vehicles. 14. Vehicles or vehicles of any particular class or description when unattended. 15. Places in streets where vehicles or vehicles of any particular class or description may or may not wait either generally or at particular times. 16. Cab ranks and stopping places of omnibuses and other public conveyances. 17. Cabs and hackney carriages not hired and being in a street elsewhere than on a cab rank. 18. For restricting the use of vehicles and animals, and of sandwich men and other persons, in streets for the purposes of advertisement of such a nature or in such a manner as to be likely to be a source of danger or to cause obstruction to traffic. 19. The lighting and guarding of street works. 20. The erection or placing or the removal of any works or objects likely to hinder the free circulation of traffic in any street, or likely to occasion danger to passengers or vehicles. 21. Queues of persons waiting in streets. 22. Priority of entry to public vehicles. 23. For enabling any police, local or other public authority, in the event of any person failing to do anything which under the regulations he ought to have done, to do such act, and to recover the expenses thereof from the person so in default summarily as a civil debt. Housing Act 1925, 15 George V, C14, Section 11, subsection 1. If, on the representation of the medical officer of health, or of any other officer of a local authority, or on any other information given, any dwelling house appears to the local authority to be in a state so dangerous or injurious to health as to be unfit for human habitation, the local authority shall make a closing order prohibiting the use of the house for human habitation until, in the judgment of the local authority, the house is rendered fit for that purpose. 2. Notice of a closing order shall be forthwith served on every owner of the house in respect of which it is made, and any owner aggrieved by the order may appeal to the Minister of Health by giving notice of appeal to the Minister within 14 days after the notice is served upon him. 5. The local authority shall determine any closing order made by them if they are satisfied that the house, in respect of which the order has been made, has been rendered fit for human habitation. 6. If, on the application of any owner of a house, the local authority refuse to determine a closing order, the owner may appeal to the Minister by giving notice of appeal to the Minister within 14 days after the application is refused. Section 14, subsection 1. Where a closing order in respect of any dwelling house has remained operative for a period of 3 months, the local authority shall take into consideration the question of the demolition of the house, and shall give every owner of the house notice of the time, being some time not less than 1 month after the service of the notice, and place at which the question will be considered, and any owner of the house shall be entitled to be heard when the question is so taken into consideration. 2. If upon any such consideration the local authority are of opinion that the house has not been rendered fit for human habitation, and that the necessary steps are not being taken with all due diligence to render it so fit, or that the continuance of any building, being part of the house, is a nuisance, or dangerous or injurious to the health of the public or of the inhabitants of the neighbouring houses, they shall order the demolition of the house or building. 4. Notice of an order for the demolition of a house or building should be forthwith served on every owner of the house or building in respect of which it is made, and any owner aggrieved by the order may appeal to the Minister by giving notice of appeal to the Minister within 21 days after the notice is served upon him, or, where the operation of the order has been postponed for any period, within 14 days after the expiration of that period. Section 39. As soon as an improvement or reconstruction scheme has been prepared, the local authority shall forthwith a. Publish in a newspaper circulating within the district of the local authority an advertisement stating the fact of such a scheme having been made, the limits of the area comprised therein, and naming a place within that area or in the vicinity thereof where a copy of the scheme may be seen at all reasonable hours, and b. Serve a notice on every owner or reputed owner, lessee or reputed lessee, and occupier, except tenant for a month or a less period than a month, of any lands proposed to be taken compulsorily so far as such persons can reasonably be ascertained, stating that such lands are proposed to be taken compulsorily for the purpose of such a scheme, and in the case of any owner or reputed owner, lessee or reputed lessee, requiring an answer stating whether the person so served dissents or not in respect of taking such lands. Section 40, subsection 1. Upon compliance with the foregoing provisions with respect to the publication of an advertisement and the service of notices, the local authority shall present a petition to the Minister praying that an order may be made confirming such scheme. 3. The Minister, after considering the petition, may cause a local inquiry to be held, and, if satisfied on the report thereon that the circumstances are such as to justify the making of the scheme, and that the carrying into effect of the scheme, either absolutely or subject to conditions or modifications, would be beneficial to the health of the inhabitants of the area in question or of the neighbouring dwelling houses, may by order confirm the scheme with or without such conditions or modifications, so however that no addition shall be made to the lands proposed in the scheme to be taken compulsorily. 5. The order of the Minister, when made, shall have effect as if enacted in this Act. Section 50, subsection 1. Where an official representation is made to the local authority with a view to their passing a resolution in favour of an improvement scheme, and they fail to pass any resolution in relation to such representation, or pass a resolution to the effect that they will not proceed with such scheme, the local authority shall, as soon as possible, send a copy of the official representation, accompanied by their reasons for not acting upon it, to the Minister, and upon receipt thereof the Minister may direct a local inquiry to be held, and a report to be made to him with respect to the correctness of the official representation made to the local authority, and any matters connected therewith, on which the Minister may desire to be informed. Subsection 2. If, on the report made to the Minister on an inquiry directed by him under this section, he is satisfied that a scheme ought to have been made for the improvement of the area to which the inquiry relates, or some part thereof, he may, if he thinks fit, order the local authority to make either an improvement or a reconstruction scheme as he may think fit, and to do all things necessary under this Act for carrying into execution the scheme so made, and the local authority shall accordingly make a scheme or direct a scheme to be prepared as if they had passed the resolution required under this part of this Act in relation to the scheme in question, and do all things necessary under this Act for carrying the scheme into effect. 3. Any such order of the Minister may be enforced by mandamus. Third Schedule. Provisions as to the compulsory acquisition of land by a local authority for the purposes of Part 3 of this Act. Provision of houses for the working classes. Subsection 1. Where a local authority propose to purchase land compulsorily, the local authority may submit to the Minister an order putting in force as respects the land specified in the order the provisions of the Lands Clauses Acts with respect to the purchase and taking of land otherwise than by agreement. Subsection 2. An order under this schedule should be of no force unless and until it is confirmed by the Minister, and the Minister may confirm the order either without modification or subject to such modifications as he thinks fit, and an order when so confirmed shall, save as otherwise expressly provided by this schedule, become final and have effect as if enacted in this Act, and the confirmation by the Minister shall be conclusive evidence that the requirements of this Act have been complied with, and that the order has been duly made and is within the powers of this Act.